Yay, it's another Blue Bacon video. Kids, you're welcome. I'm going to just kind of breeze through this a little bit. I hope you don't mind. All the words are up on the screen if you want to read them. Obviously, I'm not trying to hide anything. I'm just trying to make this as fast-paced as possible for you. He doesn't understand time, place, and manner, and he doesn't understand what content neutral means. You can tell he doesn't understand it because he says you mean it applies the expression without regard to the substance or message of the expression, and then he links me to a definition. He links me to this definition. Now, this doesn't say what he just cited there, so I wonder where I got it, because this sounds like something that he just copied and pasted, because he doesn't actually show that he understands what we posted, and I can explain that. Because I say I have put forth an argument. Read versus the town of Gilbert. Read versus the town of Gilbert. Then he links this Middle Tennessee State University article, which we'll go over in a minute. And he says it's not terribly applicable. He says 18 U.S.C. 795 does not distinguish between who is filming and their purpose for filming. This is a completely different test than what you just put up here. It's a completely different test. And remember, expression without regard. We're going to come back to that. So you didn't understand what you copy and pasted from somewhere. Now you're applying a completely different test that you got from somewhere else, and I don't know where else. He says it's also not terribly convincing considering the Toledo Blade tried to establish 18 U.S.C. 795 was unconstitutional and failed. Well, we don't know why or how. I mean, they could have stipulated to it, etc. We don't know. So unless you can actually get me documents from the Toledo Blade case, then it's really not worth you saying that. And I haven't seen you link to anything, so I haven't been able to read it. I can't verify that. I do want to advise you, though, that district court decisions are not something to hang your hat on. Ever. There's a reason why appellate courts exist. It's because district courts make mistakes. They make a lot of mistakes. More experienced judges, better judges, move up to the appellate level. And then from there, they move up to the Supreme Court's level. So don't hang your hat on district court decisions. Just because they're published, it means you could cite them. It means that it may support your argument, but the judge in your case may also just shrug and say, that's a terrible decision, and I'm not following it. Now that we have that out of the way, this is on my The President Defines video. Now he says this is a straw man. You always know it's a straw man if they start off with so you're saying, so basically, so what you mean is, that's always the setup for a straw man. This is in fact a straw man. This isn't what I said. He asks if his straw man disputes his argument. I don't know and don't care. He says you're poking at the parts of my video that I acknowledged as inconclusive but worth considering in the context of legislative intent while ignoring the more compelling arguments. I don't believe so, but if you think I have ignored a compelling argument, please state with specificity what argument I have ignored, and I will be happy to address it. I also want to point out that you probably haven't watched all of the videos I've done on you and this subject, because I've done a lot, and I understand it's a bit overwhelming, but that's why I try to make them fast. So he says, Burb, you keep claiming it isn't content neutral, but I have yet to see a thought-provoking argument to support this claim. And then he goes on to his, does 18 U.S.C. apply only to certain people filming, or does it apply to anybody who does not have permission? This is the same thing as this, which is completely different from this. Now, I'm going to attempt to use his resource to prove 18 U.S.C. to him is not a time, place, or manner restriction. This is his resource. Time, place, and manner restrictions are content neutral. Oh, look, it's a hyperlink. I wonder what this hyperlink says. Expression without regard to the substance or message of the expression. Expression without regard to the substance or message of the expression. It's a copy-paste. Congratulations. I'm arguing with someone who is copy-pasting an encyclopedia entry that they don't understand. Such is my life. Anyway, such restrictions come in many forms, such as the imposition or imposing limits on the noise level of speech, capping the number of protesters who may occupy a given forum, barring early morning or late evening demonstrations, and restricting the size or placement of signs on government property. None of those sound like our restriction against filming very specific things. This restricts photographing anything that the president defines as a certain vital military and naval installation or equipment as requiring protection against the general dissemination of information related thereto. It is specific. The content of the photograph has to be the vital military and naval installation or equipment that the president has defined as requiring protection against the general dissemination of information relative thereto. There is a specific content that the photograph has to have in order for it to be in violation of 18 U.S.C. 795. And by violation, I mean that the prosecutor has to present to the jury or the judge the photograph and has to show that what is in the photograph is, in fact, a vital military or naval installation or equipment that the president has defined as requiring protection against the dissemination of information. He has to show that it is a photograph of a top secret, secret, or confidential military installation or equipment. He has to show the content. He has to prove the content. Restrictions can survive the First Amendment challenge under a three-pronged test. To survive the First Amendment constitutional challenges, such restrictions must satisfy a three-pronged test outlined by the Supreme Court in Ward v. Rock against racism. It must be content neutral. We've already clicked that link. It's a different link. This one's content-based. I wonder what this one says. We'll get there. We'll get there. It must be narrowly tailored to serve significant government interest, and it must leave open ample alternative channels for communicating the speaker's message. Restrictions based on subject matter is not content neutral. The first prong, requiring content neutrality, will be violated by any regulation that describes permissible expression in terms of its subject matter. That describes permissible expression in terms of its subject matter. It is any photograph that doesn't contain vital military, naval installation, or equipment that the president has defined as requiring protection against general dissemination of information relative thereto is permissible. It is literally defining it based on its subject matter. Police Department of Chicago v. Mosley provides an example of a time, place, and manner regulation that failed content neutral requirement. In Mosley, an ordinance prohibited picketing within 100 feet of any school building while classes were in session. However, picketing was allowed if school was involved in a labor dispute. So picketing is not allowed unless it's involved in a labor dispute. They have to know why you're picketing in order to determine whether you have violated the ordinance. They have to know what you took a photograph of in order to know if you violated the statute. Writing for the court, Justice Thurgood Marshall observed that the ordinance describes impermissible picketing not in terms of time, place, or manner, but in terms of subject matter. Describes impermissible picketing in terms of time, place, and manner, but in terms of subject matter. Not in terms of time, place, and manner, but in terms of subject matter. So picketing is not a time, place, or manner, is not described in terms of time, place, or manner, but it's described in terms of subject matter. Remember that for later. The regulation thus slips from a neutrality of time, place, and circumstance to a concern about content. This is a concern about content. What's the content of the photo? The regulation, okay, this is never permitted. Well, it is sometimes permitted because if it survives strict scrutiny, it will be permitted. Mosley does not exemplify the only way that a speech restriction can violate the content neutrality requirements, and blah, blah, blah. We'll come back to this. We'll reference it further on in here. I think I have made my point that it isn't content neutral, but we'll continue. Does 18 U.S.C. 795 only apply to certain people filming a restricted installation, or does it apply to anybody who does not have permission from the commander to film? Well, even then, even if your weird assertion that in order to be content-based, it has to apply only to some people and not to others, this is applying to some people and not to others. I mean, there's two groups of people. There are people who have permission, people who don't have permission. And why you think permission from the commander would apply to somebody off base. I just want to point out, by the way, that your interpretation would apply to people off base. if somebody's living in an apartment complex that is adjacent to or near a military installation, and they take a picture from inside their apartment, and they take a picture of that base from their apartment, from their living room or bedroom, they're in violation of 18 USC 795 under your interpretation of it. It isn't a time, place, or manner restriction. Is it not narrowly tailored to the equipment and installations contained within a base that the Secretaries of the Armed Forces, SecDef, and President determine are protected from the general dissemination of information? You don't understand narrowly tailored either. Narrowly tailored is talked about in here. You should have read it. Narrow tailoring is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. Generally speaking, regulations are narrowly tailored unless it's sweeping. And they talk about that in here too. Sweeping prohibitions on parades, demonstrations, residential picketing, door-to-door leafleting, or handbilling. If it's a categorical ban, it's going to violate it. Typically, the narrow tailoring, it's not a tough requirement to hit. Does it not leave open ample channels of communication, such as writing or verbal discussion? You don't understand that either. The time, place, and manner restrictions are really designed for actual speech, communicative speech, while you're speaking. When a court is looking at the ample alternative channels of communication, they're looking to see if you have access to your audience. Is afforded a forum that is accessible to where the intended audience is expected to pass. So you see the ample alternative channels when you're looking at things like protesters. I don't really like the new protester pens that they do, where they move the protesters away from the event. But the test on whether or not those protesters have their ample alternative channels of communication available to them is whether their intended audience is expected to pass their little protest pens. So it's really a question of, do you have access to your intended audience? It's more of a, do you have access to your intended audience? So you're just not understanding what you're talking about, brother. Aurora Alchemy mostly does. Up until this point, all this stuff is double heartworthy. She says, from what I understand, and I'm not a lawyer, so obviously I could be wrong here, you can film the trees and grass, but not the buildings. That would mean that they have to check to see what you filmed in order to apply the law. She says, if there, I don't think I read that. But yeah, if you can film the trees and grass, but not the buildings, that is a content-based restriction. They have to look to see what you filmed in order to apply. That is perfect. If they have to check, it means it's not content neutral. Perfect. That is exactly dead on. Exactly dead on. I don't think 795 as written is susceptible to a facial challenge. Primo. Sorry, buddy. And he says, that's a great question. The limitation of what can be filmed per 18 USC 795 falls under the narrow tailoring of the statute, not the content neutrality. No, it does not. The picketing, the restriction on picketing, remember this ordinance, it described impermissible picketing not in terms of time, place, and manner, but in terms of subject matter. This doesn't talk about time, place, or manner. It talks about subject matter. It defines the photograph by the subject matter. You can't take a photograph of that. You can take a photograph of anything else in the world, but not that. It talks about it in terms of its subject matter. The regulation, the statute, thus slips from neutrality of time, place, and circumstance to a concern about content. He says, if 18 USC 795 was only enforced on a certain type of people, such as auditors, as opposed to reporters from cable news channels, because of the manner in which filming or photography would be used, then it wouldn't be content neutral. It probably wouldn't be viewpoint neutral at that stage either. And viewpoint neutral I've never seen a viewpoint neutral, or excuse me, a viewpoint based, I've never seen a viewpoint based restriction survive. This would probably be a means to silence the viewpoint of the auditors who would be critical of the military, but still allow people like the cable news channels who tend to be more positive about the military to speak. That would be a covert viewpoint based restriction and would probably fail because of that. He said, I would argue that writing about an installation would not be considered diagrams. I would also argue that. Of course, if you're copying text of a confidential document, that would be a different story, and that would probably also be a different statute. So I think I've addressed everything there. Again, read the town of Gilbert is dead on point. It's the content of the sign. They have to stop to read the sign in order to determine whether or not the sign is in violation of the particular ordinance. They have to read the sign. And the court says if you wanted it to be content neutral, you could regulate the size of the signs, because that you don't have to read the sign to figure out what it's about. You could regulate the color of the sign. You could regulate where the sign is placed, but you can't regulate the content of the sign. So I hope I covered everything. I tried to do this as fast as possible. Thanks for watching and have a great evening.